So that is a very brief overview of the work of the Attorney General's office. If you have any questions about that, again, you can utilize that chat function, or you can talk to us at the end of the presentation, but just want to give a brief overview about that. We'll now go into what we're talking about for most of the presentation today, that is consumer rights in general. Specifically, we're going to focus on retail rights, credit, and then something that goes with credit many times, the debt collection space. So your retail rights to begin with, what are some rights and protections you have in retail situations? Overarching many things, you have two implied warranties in retail sales. They are the implied warranty of merchantability and the implied warranty of fitness. Now, I want to say from the beginning that these are implied warranties, so they're not necessarily stated anytime you make a purchase. And as you can see, they're very vague. And it's going to be difficult for us to say exactly if something falls under one of these implied warranties, but we'll just try to explain them so you understand in general what they're going to say. The implied warranty of merchantability says a product must work properly for a reasonable amount of time. A product has to work when you buy it. It can't be defective is essentially what that's saying. Now again, what is working properly? What is a reasonable amount of time? That's the vagueness there. That's where it can be kind of difficult to determine exactly what it's saying. What I would say, and what our consumer protection statute really talks about are practices that are unfair or deceptive. So if you think something's been unfair or deceptive when you're sold something, that's generally an area where you can file a complaint with the Attorney General's office. The other implied warranty that you have is the implied warranty of fitness, and that says that the goods must be fit for the stated purpose. So these really work in concert with each other, because the implied warranty of merchantability is saying that something has to work, and the implied warranty of fitness is saying that it has to work for its stated purpose. So if you go to an electronics store and you buy a laptop, you get home maybe a month later, the laptop starts working, and you think that the product is no longer working properly, and the store tries to tell you, well, it might not be functioning as a computer, but I think it would really make a great paperweight, so we think it is still functioning. Right, that may violate that implied warranty of fitness. When you bought that laptop, you didn't buy it to be a paperweight, you bought it to be a computer. So even if it's working properly for some function, it's not working properly for the function for which you purchased it. And I think it's important to think of these two things in concert with one another. And if you think, again, that there's been some sort of unfair or deceptive practice here, that your product is not working and you're not getting anywhere with the business, that's the time where you may want to file a complaint with the Attorney General's office, our consumer division. Some rights you have for defective products when you buy something that is defective. To begin with, the merchant's return policy is not going to apply to defective products. Now, we'll talk about return policies on the next slide, but I think it's important to remember when we're talking about that, we're talking about returns for products that are functioning properly, not for defective products. And the merchant has to provide an option of replacement, repair, or a refund when they have sold you a defective product. Again, if you're not getting anywhere with the business, you're not getting anywhere with the merchant, that's where you can file a complaint with our consumer advocacy division. Hopefully we can get that issue resolved for you. Now, in general, returns. In Massachusetts, there's really no exact guideline as to what a return policy has to be. The merchant, the business, can really have whatever return policy they want. But what's important is that return policy is going to be clearly disclosed to you as the buyer before that transaction is completed. So it could be that all sales are final. That is a policy that a business can have. It could be that returns will only get merchandise credit. It could be that you could get a full cash refund for what you bought, but only if you return it in a certain amount of time. All of those return policies can work. The important thing is that the buyer is aware of them before the purchase is made. So if a return policy for an item is not posted anywhere in the store, but is instead only posted on the receipt, that's likely not going to be good enough, because by definition, that by the time you have the receipt, it's after you've made the purchase. It has to be disclosed to you before you make the purchase. So oftentimes you will see in retail stores that they post their return policy right in the checkout line, right as you're about to get to checkout. And it's important to take a look at that, because it has to be conspicuously, clearly disclosed to you before you make the purchase. And if you think that it hasn't been, and then you go try to return something, and the business is not saying that you're able to return it, or you remember what the return policy was and the business is now changing its mind about that after the fact, then those are areas where you could file a complaint with our office, the Attorney General's office, and hopefully be able to help you out there. Some information about gift cards as well. When you purchase gift cards, the first thing to know, in general, a gift card with an expiration date, with the date of issuance in Massachusetts is going to be good for 7 years. It has to be good for 7 years. If it's one of those gift cards that's like a credit card, it's like a Visa or MasterCard gift card that you can use many different places, those are good for 5 years. They have to be good for 5 years. If there's no date of expiration, no date of issuance on it, and you can't really show when that gift card was issued, that gift card is going to be good forever if there's none of that information on that. Gift cards in general are not subject to fees. They're not subject to depreciation other than you using them at the establishment. The only area where that's not necessarily the case is if they're issued by a national bank. And in those instances, they may be subject to depreciation. So that's just a brief overview of some gift card things there. Again, if you find a business that's not honoring a gift card that was issued only a couple of years ago, chances are they should be doing that, and that's something where you may want to file a complaint with our office. Sometimes we get questions about these as well. You hear about in the news data breaches at different retail stores, different businesses. One of the important things to know when one of these data breaches happens is what information was breached, what information got out. Was it an area where credit card and debit card numbers were breached? That information got out. The steps you should take there are to cancel that credit card or get a new credit card with a new number. If it's a debit card, contact your bank, make sure you're protected there so that you don't have to worry about identity theft with somebody using one of your cards. There are also times where your personal information is breached in one of these breaches. For whatever reason, the store had things like your social security number, and that information got out there. In those instances, you have to take a couple more steps to make sure that you're fully protected. And we'll talk about some of the steps you can take with your credit report on a later slide. But I think the first thing is to figure out exactly what information was breached, because that's going to determine what types of steps that you need to take. It's also important to know that when there's a retail data breach, that retailer has to report the information to the Office of Consumer Affairs, which is another state agency, the Attorney General's office, our Consumer Protection Division, as well as the affected residents of Massachusetts on a rolling basis as they're figuring that out. So if you do hear of a data breach at an establishment that you know that you have frequented, you maybe want to be on the lookout for something from that retail establishment informing you that your data may have been breached. And what steps you can take if they're offering you anything, offering you any type of identity protection that you may want to sign up for. Briefly, we'll just talk about credit a little bit. I'm sure most people know what a credit card is, but it's important to think about in what areas it makes sense to make purchases on a credit card, when it might not make sense, when it might be a good option for you. Obviously, what a credit card is allowing you to do is to make purchases, not using your own money, but using money that is being lent to you. Typically, you have to pay that money back within a grace period, and if you do that within 25 to 30 days of when your statement period ends, you don't need to pay any extra. You don't have to worry about what the rate is there that you have to pay back. You just pay for what you purchase. If you don't pay back within the grace period, if you're unable to pay that back for whatever reason, interest is going to be applied to what you owe. And generally, it's going to be a pretty high rate of interest. I think most credit cards we see are at least in the mid-teens, if not heading towards 20 in the upper teens there. And if you don't pay back your credit on time, it's going to lower your credit score, which is going to affect your ability to get credit, both from a new credit card and other types of credit. It's also going to affect the rate at which you can get credit, right? Are you going to be subject to being able to borrow lower amounts? Are you going to be subject to higher interest rates if you're not paying off your credit card each month? So if you're thinking about getting a credit card and you're thinking about which one you should sign up for, there's a couple things to keep in mind here. The first are the costs, right? What is the interest rate? This is a really high interest rate, though I think really if you're thinking about using a credit card, the ideal situation is that you're going to be able to pay that off at the end of the month. But we all realize that there are sometimes events in life that are going to force us to not be able to do that. And so paying attention to what interest rate could be applied should you not be able to pay it off at the end of the month is going to be really important. The other thing that goes along with that is most credit cards are going to have a yearly fee that you have to pay in order to use the credit card. So even if you pay off your credit card each month and you're paying off exactly what you purchased, you don't need to worry about the interest rate. There still is a slight cost there, a yearly fee, and it's important to pay attention to what that yearly fee is, because for some credit cards, it's fairly minimal, especially when you go over the whole year. It's not actually costing you that much per month extra to have that credit card. For some credit cards, it can be kind of a lot. Now, on the other side, are what rewards you could get from using this credit card, from using this way to make purchases. And they're also going to vary by what type of credit card that you get. Sometimes they're cash back, sometimes they're points you can apply to purchases. Sometimes there are special offers on special types of purchases, so it may be that one particular credit card really makes sense for you because you purchase a lot of plane tickets and you get a lot of points back for when you purchase plane tickets. And the yearly fee is going to be wiped out by the benefits you get from using that credit card. The other thing using a credit card can do is it provides you a little bit more protection when you're making purchases, especially when you're making purchases online and other areas where that information is being stored somewhere. You're going to get fraud alerts with a credit card. And in general, though you may have to take some steps for this, right, if there are purchases that weren't actually made by you, there were fraudulent purchases made on your credit card, it can be forgiven by that credit card company. That credit card company will pursue the person who made those purchases, and you will not have to pay that amount of money back. This is sometimes also the case when making purchases with a debit card, though I think it can be more difficult when dealing with the bank and when it was actually your money that went out to make that purchase, rather than the credit card company's money that covered that purchase. Now, of course, you don't need to worry about fraudulent purchases made with cash, right? Nobody can clone the cash that's in your wallet, but they can steal your wallet, right? And if they steal your wallet and if they steal the money that you have, it's going to be nearly impossible to get that amount of money back. Whereas if somebody steals your credit card or steals a debit card, you could cancel that before they're able to make any fraudulent purchases. This is all just a very long way to say, this is a way to make purchases. It may be a good way for you to make purchases, and it is going to provide you a little bit more protection from these fraudulent purchases if you do choose to use a credit card, but it's important to keep all of these things in mind when you think about signing up for one. Now, as we mentioned briefly, just talking about credit and your credit report, what your credit report is your credit history. Obviously, it shows the different lines of credit that you have. It can include things like revolving accounts, revolving credit accounts like a credit card. It would include things like your mortgage. It would include things like student loans, an auto loan that you have. Your credit report is going to have all that history. It's important that we all check our credit at a regular basis. You get a free credit report from each of the 3 credit reporting bureaus. That's Equifax, Experian, and TransUnion, once a year. So if you spread it out, you can check your credit without impacting your credit every 4 months. I think it's good for all of us to get in the habit of doing that. I myself am guilty of this, but I know many of us have apps with our credit card or with our bank account that allows us to take a quick look at our credit report. It's easy, you press a couple buttons, but in general, that app, that credit report is only pulling from one of the credit reporting bureaus, one of the credit reporting agencies. So if you're constantly checking your credit with TransUnion, you may not notice any problems there. But there may be an error on your credit report with Experian, or there may be a fraudulent charge, a fraudulent line of credit that for right now is only showing up on Equifax. And you're not going to see that unless you're trying to check every single one of those credit reporting agencies. You also don't know what a potential creditor is going to check when they're trying to evaluate you for a new line of credit. And so if you do find any issues on your credit report, it's important to take care of those, important to start an investigation into that with the credit reporting agency. to make sure that's taken care of, because again, it does affect your ability and the rate at which you can be given credit in the future. Now, in terms of identity theft, we talked about this a little bit on that retail data breach slide. What can you do to protect yourself from identity theft if your personal information has been compromised? And I think really it's probably best for all of us to get in the mindset that somebody somewhere probably has our personal information. It may not be the case, but it's better to be overly cautious here. And with the amount of data breaches and the size of some data breaches, like the Equifax data breach, I think it's good for us all to get in the mindset that we're not above identity theft, that we're not doing it so well that no one could have possibly stolen our identity, because we live in this technological age where our information is stored a lot of places. So it's important for all of us to know the steps to take to protect ourselves from the ill effects of identity theft, even if we can't prevent 100% someone from trying to steal our identity. So there are two things you can do with the credit reporting agency to help protect your identity in these instances. The first is what's called a fraud alert. It's an alert that goes on your credit report. It tells any potential creditor that you're worried about identity theft, and they should take additional steps to verify that it's actually you who is requesting this new line of credit. You place it with one of the credit reporting agencies. They share it with the other two. It's good for a year when you place it. It's a good first step, but unfortunately it doesn't stop all identity theft. The more drastic measure you can take is what's called the security freeze. You may also hear it referred to as freezing your credit. When you freeze your credit, what you're doing is you're stopping any hard inquiry into your credit. So any creditor who wants to approve you for a new line of credit is not going to be able to see your credit history. And for that reason, it's very, very unlikely that they would give you a new line of credit without being able to see your credit history, without being able to do that hard pull of your credit. So that's likely to stop any identity thief from using your credit. But a couple things to keep in mind. It's also going to stop you. You're not going to be able to get a new line of credit while your credit is frozen. So if you're actively using your credit, if you're about to get a new car, you might need an auto loan, you're about to apply to refinance your mortgage or for a mortgage in general, you need a new credit card for whatever reason, right? It's important to know that having that security freeze is going to stop you from getting that new line of credit. So what you would have to do is what's called thaw your credit. You lift that security freeze from your credit. When you place a security freeze, you're going to get a PIN number. Very important to keep that PIN number somewhere safe, if you have a fireproof safe or something like that, an area where you can access it, because you're going to need that PIN number in order to thaw your credit. Other things to keep in mind, it used to be that there was a charge to freeze and thaw your credit. That's no longer the case in light of these data breaches, especially that Equifax data breach. Both federal and state legislation has made that free. So you can freeze and thaw your credit without that charge. The other thing that you should keep in mind here is that if you yourself are applying for a new line of credit, well, I guess I'd just go back for 1 second. With the security freeze, what you have to do is you have to place it individually with each of the credit reporting agencies. So that fraud alert, you only have to place once. A security freeze, you're going to have to place 3 times. Now, if you go to thaw your credit because you want to apply for a new line of credit, you can ask that creditor if there's a particular credit reporting agency that they use. That way, if the person trying to approve you for a new auto loan only checks Experian, you don't have to lift the security freeze with TransUnion and Equifax, and you're just making it a little bit easier for yourself. That's not always going to be the case, right? You may have to remove it and thaw it and then put that security freeze back on with each of them, but it's important to ask. It can save you a little bit of work if they're only going to check that one. Again, a security freeze is the best way to protect yourself from potential identity theft, but it is important to remember that it is also going to affect your ability to be approved for a new line of credit, and making sure that you are in a position where you can take the steps to lift that security freeze if you yourself want that new line of credit. So with that, I'm going to turn things over to my colleague Peter, who's going to talk a little bit more about our work in the debt collection space. Any questions at any point, please utilize that chat function. We'll also stick around at the end of the presentation in case something comes up that you have a question about at the end. But thanks for listening to me, and I'll turn this over to Peter.
Thanks, Tim. I'm just spinning the computer around here and getting situated. Tim covered a good number of topics there. And, I'm going to do a little bit of a different approach here, where we're going to take a bit of a deep dive, a deeper dive, I guess you could say, into the world of debt collection. And just before I get into that, let me say again, my name is Peter Downing. I'm an Assistant Attorney General in the Consumer Protection Division. One of my areas of focus is debt collection. And so my day-to-day work is investigating and litigating and bringing enforcement actions in the field of debt collection and consumer protection. So right now you'll see that there's a bulleted list of topics that I'm going to cover. And I think the easiest way to think about this is the first three topics are ways to look at debt collection from the consumer's perspective, and sort of decipher what's going on, who's trying to collect money from a consumer, and what can be done. The last three bullets I'll get into towards the end are particular initiatives that our office has taken, ways that we've sought to combat unfair and deceptive debt collection. And those you'll see some particular initiatives that are either specifically located in certain areas of the state or outreach that we are doing in that space. So, in the world of debt collection, and I guess let me also say that in advance of this presentation, I looked over the list of attendees, and I saw that it looks like many of the folks who are on here are in organizations or in local government or city offices that may have a direct interface with consumers or residents. And when I think about that, it makes me want to back up and say that likely debt collection is a topic that could come before you in any kind of, or in many different ways. So yes, it may be true that someone's going to come ask for help because a debt collector is coming after them, but it's also just as likely that someone's coming to talk to you because they need help with their housing situation, or they're facing problems with medical bills or health insurance, and they need help understanding how to navigate all the complexities of that. Or someone's going to come to you who needs help applying for benefits, maybe housing benefits or Social Security benefits or some form of state benefits. All those people are people who also likely will benefit from some considerations about debt collection, because often debt collection goes hand in hand with individuals who are experiencing financial hardship. And when you encounter people who are experiencing financial hardship, debt collection is often going to be one of the areas where it's going to be very helpful for you to sit down and figure out what's happening, what can be done, and there are a number of things that can be done. I think one of the first things is to figure out what's happening and who's actually trying to collect the money, because that can be one of the most confusing parts of the whole process. So, as I put here on the slide, there are a number of major players in the debt collection space. So first of all, we have original creditors, and by that I mean people like, for example, banks. So a bank will issue you a credit card. They're the original entity that issued you the credit, and if you eventually fail to pay back the bank itself may reach out to the consumer and say, you're now in default on this credit card. We are seeking to collect the balance. So a bank can be an original creditor, but also you can also have things like a dentist's office, who performed some sort of dental procedure and did it on credit. You could also have, say, a furniture leasing or rental enterprise. Any entity that extends credit to a consumer would be the original creditor. So those people who extend credit, those companies who extend credit, can also then attempt to collect it from a consumer. And these cases will be probably the most straightforward for you to understand, because the consumer is likely to remember, oh yeah, I had a credit card with Bank of America, and now Bank of America is trying to get me to pay back that amount. It gets a little more complicated though, because sometimes Bank of America or Citibank or even your dentist's office who extended credit to you to perform a root canal or something is going to say, well, yes, this consumer's in default, but I don't want to continue trying to collect on this debt. I'd rather just have it off my books and take sort of the loss and move on. So that brings up this whole second ecosystem where companies specialize in buying old debts. So that's what we call debt buyers. So a consumer may come to you and say, I never had a loan or a credit card with, say, Portfolio Recovery Associates. What is this? And that's where it'll be important to figure out, okay, we're now talking about not the original company that issued the credit, but someone who subsequently bought the credit. And it can be a little bit confusing because sometimes people will not understand the difference between, say, a debt collection agency and a debt buyer. A debt collection agency is the entity who is the one making phone calls or sending letters to the consumer on behalf of someone else. So in the Bank of America example, say Bank of America wants you to pay back the credit card. They can hire a debt collection agency, and that debt collection agency will then be the company who places calls and sends letters. So the consumer may say, I'm confused because it says it's Bank of America, but I'm getting these calls from collection agency ABC. So who do I actually owe the debt to? So in that example, the debt collection agency is collecting on behalf of someone else, either the original creditor, or in some cases, they can actually collect on behalf of debt buyers. So you can see how this things become somewhat derivative here, because you can have a debt collection agency working on behalf of either the underlying creditor or someone who has subsequently bought the debt. But it doesn't stop there. Not only do original creditors and debt buyers use collection agencies, but they also use debt collection law firms. So what this scenario is likely to involve is a situation where the consumer is either implicitly or explicitly being threatened with litigation if they don't pay their debt. So in the sort of chronology of debt collection, what typically happens is that consumers will be subject to phone calls and letters, and at a certain point, the owner of the debt is going to say, well, I haven't gotten paid yet, and I'm going to resort to legal means, such as threatening to sue someone. So that's where the debt collection law firms come in. So debt collection law firms can also be sending letters to consumers. So as you'll see here, there are any number of players who could be sending letters to a consumer. And for you, the important thing is to figure out who is making the communication, and then who is the debt owed to, because those two people oftentimes are different. And then finally, and this somewhat relates to what Tim had talked about, credit reporting agencies play a role in this too, because credit reporting agencies are the place that debt collectors, debt buyers, collection law firms can report negatively about the fact that you have a delinquent debt. So consumers will sometimes learn about a debt that's in collection not directly from a call or letter, but by running their credit report. And they'll see, oh my gosh, Bank of America has now put a negative report on my credit for this defaulted credit card. So I want to turn to what it looks like in Massachusetts with debt collection. And the first thing to know is that debt collection is sort of astonishingly pervasive. It affects a broad sort of swath of Massachusetts citizens. So here, we have in this slide, 1 in 4 consumers has a debt in collection. So it's likely if you're seeing someone who is having financial difficulties, they are likely one of these 1 in 4 consumers. And this is particularly a problem, and I think disproportionately so for consumers who are elderly, poor, disabled, with limited or no English. These consumers are particularly likely to have debts in collection and to be vulnerable to any unfair and deceptive debt collection practices. So if you have consumers who fit that criteria, I would be particularly wary and alert to any debt collection issues. So debt collection takes the form not only of calls and letters to a person, but also lawsuits. And the second bullet here points out that we have almost 2 million lawsuits filed between 2004 and 2013 against consumers to collect debts. So in many ways, the lawsuits by debt collection law firms have become a standard part of the debt collection process. So if you come across a consumer who has been sued, you'll know that this is one of basically millions of consumers who are being sued, and debt collection lawsuits are very common. That's not to say they're not frightening and probably feel to the consumer like there's no way out. But it is a very common thing. We see it a lot in the complaints to our office, and there are definitely things that you all can do to help a consumer who is facing a lawsuit, short of appearing in court. And mostly what I'm thinking about is helping them understand what is that issue and what are the resources they can draw on. So when consumers have debts, the amount in collection is typically not small. Right here we're saying that we're $4,600 is the average amount in collection. So that, for many consumers, is going to be basically an insurmountable debt. Many people would find it difficult to pay off that amount in one lump payment, let alone over a year or so. So when consumers are faced with a lawsuit, one of the largest problems we see here is they don't know what to do. And when they don't know what to do, oftentimes what they do is nothing. And in many ways, that's the worst of all possible outcomes. So unfortunately, what we've seen is that consumers, when faced with a debt collection lawsuit, don't do anything, and as a result, default on the lawsuit. And that's to say that instead of going to court and appearing in court to at least put forward their side of the argument, they stay home or don't let the court know that they need a different date. And so we're seeing that on average between 75 and 90% of these debt collection lawsuits, these millions of debt collection lawsuits, are going unchallenged, and the debt collectors are automatically winning and the consumers are automatically losing. So there are a number of protections that consumers have. There is the Massachusetts Consumer Protection Act, which, as Tim has said, prohibits unfair and deceptive trade practices. So debt collection is one of those practices that often falls in the realm of unfair and deceptive. We also have a particular law, 93 Section 49, which has prohibitions on unfair, deceptive, and unreasonable debt collection practices. Thirdly, one of the sources of protection is the Attorney General's debt collection regulations. These regulations, as I'll mention in a few slides here, have I think, some of the most useful protections that you as consumer-facing advocates can avail yourselves of. And then finally, there's the Federal Fair Debt Collection Practices Act, which has been in effect since the 70s and establishes somewhat of a floor for what is unfair and deceptive in the debt collection space. So when we think about problems in the debt collection space, there are some of, I think, the most common reoccurring problems here, and things that when you are trying to piece out what problems any particular consumer you're dealing with has, it's helpful to keep these in mind. First of all, in order for a debt collector to genuinely be owed the debt, they have to be able to prove that the consumer actually owes the debt and that the amount owed is correct. And oftentimes that's not so easy to do, especially when the debt collector is collecting not on behalf of, say, Citibank or Bank of America, but on behalf of someone who bought the debt from that bank, or someone who bought the debt from the person who bought the debt from that bank. So you can see that if you layer this process of debts changing hands, it's possible that, and we've seen that it's very common for the debt collector not to actually be able to prove how much is owed. So second, in the context of debt collection litigation, we often see that although consumers are getting letters that basically threaten lawsuits, that make it seem that this law firm is going to bring to bear all of its legal resources against the consumer, that in fact most of these collection law firms just churn out lawsuits with little to no review by attorneys, which can in and of itself mislead consumers about how much the attorney has reviewed the file, how much evidence there is to support the case. So we, in one of our somewhat recent settlements against a debt collection law firm, Lustig, Glaser & Wilson, we took issue with that law firm for threatening hundreds of thousands of consumers with lawsuits, and in many cases doing little to no review of any of the documents to ensure that the consumer actually owed what they said they owed. The third problem, and one that I would strongly urge everyone to be on the lookout for, is that when you're dealing with vulnerable populations, elderly people, individuals with disabilities, be on the lookout for consumers who receive Social Security or disability benefits, because these forms of benefits are what we call exempt income. And what we mean by that is they're exempt, these forms of income are exempt from any requirement that a person be ordered to pay this in court. So if a debt collector is trying to get someone on Social Security to pay a debt, and they say, well, we'll have to take you to court and the court's going to make you pay, that's actually, that could be a deceptive statement, because the court, in fact, would not order someone to pay their Social Security benefits. So if you have someone who is on Social Security, someone who, say, is in an assisted living facility or a nursing home, it's really important to flag this issue, and you can potentially raise it with the debt collector to say, look, this person really has no income that you could get at. And this income, the Social Security, for example, is really essential for their day-to-day living. The fourth problem, and I think this is probably one of the sources of our most significant complaints to our office about debt collection, is that simply debt collectors are making repeated calls and sending one letter after another to consumers to the point where it becomes sort of harassing and abusive. And finally, there's a real problem we've seen in Massachusetts with consumers being threatened with arrest for failing to pay their debts. And if you see a consumer who has gotten a threat of arrest, this is definitely something to be aware of, and I would suggest to let our office know about, because we often see consumers essentially empty out their pockets when debt collectors say, well, if you don't pay us, you're going to be arrested, because that's not the way the law works in Massachusetts. You can't be jailed for failing to pay a debt if you have no ability to pay that debt. So you do have legal protections. I mentioned some of the statutes a bit ago, and this is a little bit of a description of what those sort of specific protections provide. First of all, I guess as someone interfacing with a consumer about a debt, you can take steps to seek validation of a debt. And what that's going to do is this gives you the right to go to the debt collector and say, before I pay you, before anything else happens, I want you to essentially prove to me that the consumer owes this debt in the amount that you say to the person you say it's owed. And this requirement that a debt collector validate a debt is contained within the Attorney General's debt collection regulations. It's worth noting that you need to seek validation of a debt within 30 days of the first contact from a consumer. Oftentimes, you'll see consumers well after the initial 30 days. So I would suggest, sort of as a practical tip, even though our regulation requires the validation request within the first 30 days, it usually doesn't hurt to try to seek validation at a later point. Many debt collectors will still provide you the information. The second thing here is consumers have protections. You can't call so much as to harass or abuse a consumer. So we have the second bullet here that says limits on communication. What we specifically mean is that debt collectors cannot call a consumer more than twice in a week. So if you're hearing stories like, the phone rings off the hook, they keep calling, that's an area where there's a clear violation. I would certainly bring this issue to the Attorney General's attention, because that's something that we can put a stop to. Again, if someone is threatening arrest or imprisonment, that's clearly illegal. It does happen, and it's often a tactic used to get someone to pay. If you see this, I think first of all, you can know that it is a false threat, and secondly, it's something that our office would want to know about. Third, or I guess fourthly here, not all debts can be collected. After a certain point, when they get too old, a debt becomes what we call time barred. And in Massachusetts, you can't collect on a time barred debt, there's a caveat here, unless you include a disclosure to the consumer that there is no requirement to pay the debt because the debt is no longer legally enforceable. It's a confusing topic. It's worth being aware of insofar as try to figure out how old the debt is that the consumer is being urged to pay. If it's more than 6 years old, there's a good chance that this is no longer a legally enforceable debt, and that's going to give the consumer a really strong position to argue against paying the debt. So our office, as Tim had mentioned, has our Consumer Advocacy Response Division. Debt collection is an abundant source of complaints. We get upwards of 750 complaints a year. These complaints are actually really helpful, not only in that we can serve those consumers often, but it also provides an important picture to someone like me who is in an enforcement and investigation role of what is happening on the ground. So I would certainly urge you, if you have individuals who are experiencing problems with debt collection to file a complaint with our office. And through those complaints, we often get good results through our non-attorney advocates who can reach out to the debt collector, the debt buyer, and often get some pretty favorable results. I'm going to turn now to sort of a more specific topic. I'm looking at the time here. We're approaching an hour. I guess, Tim, are we still within our time frame? Okay. All right, great. So our office has been well aware of the problems that consumers face when they go to court facing a debt collection lawsuit. What we've seen is that when consumers are sued, as I said before, one of the main problems is that consumers don't know what to do and they often don't appear. This results in consumers defaulting on the debt and automatically losing. Even if consumers don't default, what we found is that consumers have a real uphill battle to know what to do or how to even get assistance if they went to court. So what the office has done is we have partnered with a number of local legal services organizations such as Greater Boston Legal Services, Volunteer Lawyers Project, South Coast Legal Services, to have a lawyer for the day go to court in a few court locations and be there so that when consumers show up for a debt collection lawsuit case, they have someone to help them. What our office is doing as part of this project is sending out letters to the consumers in advance of the court date and saying to those consumers, make sure you go to court, number one, and number two, once you get to court, there's going to be someone there to help you. And the goal of this letter project and Lawyer for the Day project is to make sure people go to court, i.e. reduce the rate of default, and increase the number of people who are actually getting legal assistance once they get there. So we are operating this clinic in at least 4 locations right now: Dorchester, Roxbury, New Bedford, and Chelsea. So if you have consumers who are within those courts, that's good news for you because they can, if they're being sued, go and get legal help. Like I said, here are partners. And this here is a picture of the letter. So maybe a consumer is going to walk into your office and say, I got this letter from the Attorney General's office saying I've been sued by a debt collector, but I can go and get help in a court. So if you see someone walk into your office with this letter, I guess take that as a good sign that there's a way a consumer can get free legal services if they go to court. Our office has been sending these letters out for, what is it now, 4 years, Tim? 3 years?
3.5.
3.5 years, okay. And we've helped many hundreds of consumers and over the course of that time saved, several $1 million for consumers who went to court and were actually able to win their cases. Right, so as I was just saying, the results of this clinic has been getting people to go to court, saving them money, and we've been able to work with some of the local legal services organizations to grant out money. I'll mention this is sort of taking a turn to policy and legislation, but our office is supporting the Debt Collection Fairness Act, which is in the Senate and the State House. This would make several important changes that would protect consumers. For example, it would make the time that a debt collector can collect on the debt shorter than it is currently. So it would go from 6 years to 3 years without being beyond the statute of limitations. It would sharply limit the ability to issue arrest warrants to consumers, and it would increase the amount of money that is exempt. Right now, in addition to particular kinds of funds such as Social Security income, you have a basic living wage that is exempt from garnishment, and this would raise that to slightly over $1,000. So I guess kind of wrapping this up, I would say be on the lookout for some of the issues that I described. Definitely refer people to our Consumer Advocacy Division, and we can support the Debt Collection Fairness Act when that moves through the legislature. There we go, and I think I'll turn it back over to Tim to wrap things up.
All right, thanks, Peter. So we will stick around for just a couple minutes. I know, folks, thank you for sticking on. I know it's been a little bit over time. Just in case anybody has any questions, but thank you again for joining us. As I said, we'll stick around just to make sure we didn't miss any questions, and if folks have any other questions, but thank you again.
This is Peter again. I see that it looks like Ellen asked, when can a civil arrest warrant be issued under current law? That's a good question because they are still lawful. And the way this works is the only time someone can be subject to a civil arrest warrant for a debt collection matter is when a court has ordered you to come to court. And this will often be after there is a judgment against the consumer. The court will and can order a consumer to come to court so that the court can determine whether the consumer should pay the debt. So if the consumer fails to go to court and basically ignores the court's order to appear, then the court basically can use the arrest warrant as a way to force the consumer to come into court. So the arrest warrant in that circumstance, and this is the important distinction, is being used by the court in order to get the person to appear in court. It is not something that the debt collector can use to force the person to pay. So in other words, it's not an arrest for failing to pay the debt, it's an arrest for failing to obey a court's order. Hopefully that helps.
And the other question we're seeing here, how often are the debt collection court clinics held? That's really by the schedule of those various courts. Some of those are weekly, some of those are every other week, some of those are 4 weeks out of the month. It's really whenever these courts have consolidated small claim sessions just for debt collection matters, that we have this, our office sends those letters and our partners in legal services are able to provide that lawyer for the day program for those who qualify.
Yeah, okay, so here's another really good question. Could you please explain